In September of 2019, under pressure from organized labor, the California legislature passed AB-5. It was signed into law by the governor the following day. The bill codified the new worker classification test, making it much more difficult to be considered an independent contractor under state law. AB-5 has generated a great deal of controversy and uncertainty. The question of classifying workers as employees versus independent contractors is central to the rise of the internet economy. Technology has enabled greater flexibility for individuals to start and run their own businesses, to work outside the traditional confines of employee. Federal employment laws, which started with New Deal-era protections for workers, define employees with balancing tests. State law often imposes more rigid rules, with backing from organized labor, and often supported by lawmakers looking for guaranteed revenue from employment taxes and withholdings. Many jurisdictions use a formulaic ABC test. Its virtue is that it's easy to apply. However, it takes away flexibility for parties that want to decide for themselves how to structure their relationships. California AB-5 is the latest example of such a test. It presumes that an individual is an employee unless she satisfies all three elements. A, the business does not control the individual's performance of the service. B, the work is outside of the usual course of the business operations. And C, the individual is operating an independent trade, occupation, profession, or business. Other states have similar ABC tests, but California's test is uniquely difficult for entrepreneurs and businesses. The B prong prohibits the workers from being independent contractors if they are providing services that are integral to the hiring entity's business model, regardless of what steps they've taken to set up their own business and to be truly independent. A worker performing standard business operations of the company hiring them must be classified as an employee. In most states, a worker could still be allowed her independence if she's performing the work in her own space, but not in California. California's new rule says it doesn't matter where the work is performed. Advocates for AB-5 maintain that the stricter ABC test is necessary to prevent companies from exploiting workers. But many are asking whether this goes too far in curbing freedom for entrepreneurs. The test makes it impossible for workers to start their own businesses and work independently if their skills fall inside the usual course of business operations for the company that might hire them. And existing businesses now feel compelled either to convert independent contractors into full-fledged employees or to stop working with them altogether. That's because they face major liabilities if they errantly continue treating workers like contractors. Meanwhile, labor advocates are pushing AB-5-style legislation in other states, and even in Congress. Whether lawmakers follow or reject California's model may have major impact on entrepreneurialism in America. Should workers need to lose their independence to keep their livelihood? How do we balance innovative business models with concerns about worker security? What are the trade-offs between independence and security for workers? How do we deal with these trade-offs in worker classification laws?